Kevin De Mastro to terminate my record in the federal SEVIS system. I was terminated from my job effective January the 6th. However, the university did not notify me until January 25th that in addition to terminating my job, the university had also terminated my record in the SEVIS system effective January the 6th, despite the fact I was in the process of appealing my termination. Because UCSD has terminated my record in the SEVIS system effective January the 6th, 2011, I currently cannot legally remain in the country beyond this Saturday, February the 5th, 2011. The solution. Please direct both Belinda Helen, her supervisor, Donnell, and Kevin De Mastro to immediately correct Kevin's erroneous termination of my record in the SEVIS system. Please additionally direct the Labor Relations Office to place me on unpaid leave. This will provide me with a fair chance to appeal my termination. Under the SEVIS rule, if the RO or DSO, foreign student officer, erroneously terminates a record, the officer may immediately correct the record by following procedure for reinstatement of the DS-2019 and returning the scholar to active status. Kevin's action at Belinda's direction was an erroneous termination because under the collective bargaining agreement, immigrant researchers like me are entitled to the same rights as U.S. employees. I should have been placed on unpaid leave pending a final determination of the labor dispute surrounding my termination, which both I and the union believe was unlawful. Additionally, I want UCSD to work with the union to create a record to be sent to the Department of Homeland Security to support why this is an erroneous termination in an expedited fashion. In light of UCSD concern, I, Dr. Helen, will agree to refrain from any UC appointment, either voluntary or paid, pending the outcome of the arbitration. We, Dr. Helen and my union, UAW 5810, propose to expedite this matter to arbitration. We ask for the earliest dates from all arbitrators, and we should select the arbitrator who has two available dates and can issue a decision within 90 days from today, so it is resolved, while I'm still on appropriate unpaid leave. Please follow up my union representative, Christine Pettit, at your earliest convenience.
Mr. Donnell, can we count on you to direct the correction in the SEVIS record to make sure that Dr. Helen has a chance to stick around and have her appeal fully heard by an arbitrator?
You can count on me to do what is required by the law and the agreement.
Can you be more specific?
That's all I'm prepared to say at this time. This matter is being reviewed. We take the statement seriously, and there are others I need to discuss your situation with. That's all I can say today. Yeah. This isn't litigation.
Yeah. Well, so, as you know, the union and the university, we're happy to work together and have harmonious labor relations. We prefer harmonious labor relations. We'd prefer this had been resolved some other way. But the fact of the matter is that people on campus are very angry that the university is interpreting both the law and the collective bargaining agreement in a completely erroneous manner. The bottom line for us is that the collective bargaining agreement and applicable law says that international postdocs and domestic postdocs have the same rights and must be treated the same under the law. And by definition, if a postdoc is forced to leave the country because she's an immigrant researcher and thereby can't finish the appeals process, then she's not being given the same rights as a U.S. postdoc. And that's not fair. That's fundamentally, it's immoral, it's wrong. Just think about it counterfactually. If Dr. Wilda Helen had happened to have been born here and had the exact same job, she would have the chance to fully appeal this to an arbitrator. and it's arbitrary and capricious for the university to interpret the law and the collective bargaining agreement as saying she has to leave the country. That's wrong. The university can change her SEVIS status, correct it as an erroneous mistake, and give her the right to be here. And everyone in this room and 10 of their friends are going to be really angry if that doesn't happen before Saturday. It's an assault on immigrant workers. It's an assault on Dr. Wilda Helen. It's an assault on all immigrant postdoctoral researchers, immigrant students. It's an assault on everyone in the University of California system that is an immigrant and a worker at this institution. And it's got to be fixed.
Well, thank you. I hear you. We hear you. We do not take this matter lightly. It's being reviewed by Office of the President, by the attorneys that work for Office of the President, as well as the attorney on this campus, as well as my office. There are a lot of people looking at this. I'm not in a position to give you any answers today. We have Dr. Helen's statement. This is new information. It will be presented to all the people that we are working with, and we will be responding shortly. Thank you very much for bringing new information to our attention. And I encourage you to continue to do things like this, because this is what keeps issues on our radar screen. This is important. This is a new union contract. The university has made certain promises, as has the union, and it affects you all. So we're all trying to do the best we can to live up to the promises we've made. It's going to be a learning process. To the extent you and the union can educate us on what the agreement is, we appreciate that. We're both going to make mistakes. We're reviewing this. This is a case of first impression in the system. So it's a learning process. I know Dr. Helen is in a very precarious situation. I feel bad about that, but I'm not in a position today to comment beyond this. So thank you.
Can we expect an initial response before Saturday from the university?
I don't know.
That would be at least fair to have some response.
I don't know.
I mean, stonewalling it is not exactly a response, and so
I wouldn't characterize it as stonewalling.
if there's no response, it's stonewalling.
You all have probably been with the university long enough to know it's a big bureaucracy. I don't make this decision by myself. There are a number of people who need to be consulted. So please don't label it as stonewalling. Please accept that we're trying in good faith to work through these issues. I won't say that what you're doing is stonewalling or being unreasonable. I don't know you well enough to make that assessment. So please give me the benefit of the doubt. This is the first time this has come up under a new contract. Be fair with me.
And what?
The university can make happen what it wants to happen. It can like skip your kind of practice to get whatever it wants. So why can't it do that today?
I am a graduate of this university, 1972. And I've worked at this university since 1982. The university is not all powerful.
Well, in this particular instance, I mean, it's really a keystroke.
Yeah.
I mean, it was a person that did it. There's someone on the campus, Kevin Del Mastro, that is in the International Center and deleted Dr. Wilda Helen's record from the SEVIS system. And there is a provision under the law, under SEVIS, that says you can just reverse that if you state that it was an erroneous deletion. That's all it takes. There's nothing more than that needs to happen.
Can I comment on that?
Certainly.
We appreciate very much that the union and the union attorneys highlighted those legal provisions. Ever since those legal provisions were highlighted, we've been in consultation with campus counsel and university attorneys. I am also a lawyer, and all I can tell you is different lawyers have different assessments and interpretations of the law. So again, that's not stonewalling, sir. That's giving the university the right to have the benefit of their counsel, just as Dr. Helen has the right to get the benefit of the counsel of the union. We're working through this together.
Right. And what we're all here today to say is that, you know, this is all about probabilities. Like the law, sure, there are risks at every juncture about interpretation, and the university is limiting its liability here. And, you know, we're here to say that that a broad interpretation of limiting the university's liability here is profoundly inappropriate and immoral when it means that the collateral damage from delaying a decision and not acting promptly is the potential destruction of someone's career.